The young prodigy yelled at the judge, "You're the ignorant one!" Silence took over the courtroom. "Nobody yells at Judge Michael J. Callis. That was the first thing they told you when you were assigned to his courtroom." Not in writing. There was no written orientation for Courtroom 6 of the New York State Supreme Court, 3rd Judicial District, Albany County. It was the kind of knowledge that moved through a building the way all important unwritten knowledge moves. Through hallways, in the elevator, at the coffee machine, in the 30 seconds before a hearing started, and the clerks were still arranging their papers. Nobody yells at Judge Callis. Nobody interrupts him. Nobody questions his citations, challenges his timeline, or suggests in any register that he could interpret as adversarial, that he might have gotten something wrong. He had been on the New York State bench for 23 years. He had the grey-streaked hair and the forward-leaning posture of a man who had spent 2 decades making rooms smaller simply by entering them. His nameplate sat at the front of his bench, Judge Michael J. Callis, in the kind of heavy silver lettering that communicates permanence, the specific permanence of someone who has decided they are not going anywhere and has had that decision confirmed, election cycle after election cycle, by the particular machinery of a county where certain names carry certain weights. He leaned over that bench now, with both hands flat on the wood surface and his face at an angle that turned his expression into something between a grimace and a challenge. And he looked at the girl standing in the center of his courtroom, as if she were a problem he had already solved and was simply waiting for the paperwork to confirm. She was 15 years old. She stood with her arms crossed over her navy blazer, her dark hair pulled back in a loose bun that had not been arranged with any special care for the occasion. And she looked back at him the way she looked at everything, directly, steadily, without the flinch that most adults in his courtroom learned to produce as a form of social currency. She was not performing calm, she was calm. There is a difference, and Judge Callis, who had spent 23 years reading the difference in defendants and witnesses and attorneys, was reading it now and finding it more unsettling than he expected. Her name was Sophia Reyes, and she was, in the estimation of everyone who had taught her, examined her, or spent more than 20 minutes in conversation with her, one of the most intellectually exceptional 15-year-olds anyone in the Albany school system had encountered in 30 years of collective professional experience. None of them were in the room. The room held her court-appointed guardian, a tired family court attorney named Daniel Park, who had been assigned the case 4 days ago and had read the file twice on the train to the courthouse that morning. It held a prosecutor from the Albany County DA's office who was 27 years old, and who had, in the 40 minutes since the hearing began, developed the specific expression of someone who has understood that the proceeding they are participating in is not going the way the proceeding was designed to go. It held a gallery of approximately 35 people, reporters, law students, several individuals who had driven specifically from the school district involved and who sat in the second row with the careful attention of people who have a stake in the outcome that the official record does not capture. And it held, in the back row closest to the exit, a woman named Dr. Ann Whitfield, who was the director of the State Education Department's Office of Gifted and Special Programs, who had received a phone call 8 days ago from a school principal in the Rensselaer Central School District, and who had driven to Albany that morning because what she had been told on that phone call had crossed every professional threshold that her 31 years in education had given her. None of them had expected what happened next. To understand why Sophia Reyes was standing in that courtroom with her arms crossed and her folder, and the specific quality of composure that Judge Callis was finding more unsettling than he was prepared to admit, you have to understand where she came from. Not in the abstract sense of background and circumstance, the shorthand that courts and administrative systems use when they mean to convey that a person arrived at their current position through a series of disadvantages that the system notes but does not especially alter itself to address. In the specific sense of what her life had looked like for 15 years, and what that life had given her, and what it had required of her in exchange. Her mother, Rosa Reyes, had come to Albany from the Dominican Republic when Sophia was 2 years old, following a cousin who had found work in the hotel industry near the state capital, and who had described Albany as a city with opportunity. A description that was true and incomplete in the way that most descriptions of opportunity are true and incomplete, meaning the opportunity existed, but it existed in the specific form of long hours and modest wages, and the continuous low-level effort of navigating systems that were not designed with you in mind, and that communicated this in ways both explicit and invisible, depending on the context. Rosa worked as a housekeeping supervisor at a hotel 12 blocks from the apartment where she raised Sophia. She had worked there for 11 years. She was good at her job in the thorough way of someone for whom the job is also a form of integrity. She trained her staff carefully. She maintained standards that her management acknowledged without especially rewarding, and she had never in 11 years been late for a shift. A fact she was not particularly proud of because she did not consider it exceptional. She considered it the minimum. You showed up, you did the work, you went home, you made dinner, and you helped with homework, and you slept for 6 hours, and you got up and did it again. What she had given Sophia, through the specific texture of this life, was not money. She had given her something harder to quantify and more durable, the understanding that the world does not adjust itself to you, and that the correct response to this understanding is not resentment, but preparation. You learn what you can learn, You find what is available to you. You do not wait for someone to offer you the resources you need. You identify the resources that exist, and you make them serve your purposes. Sophia had taken this understanding and run with it in directions her mother had not specifically anticipated. The school library was the primary example. Sophia had discovered at 11 years old that the Rensselaer Central School District's library had an academic database license that gave students access to legal records, public filings, peer-reviewed journals, and government databases that most adults in the district did not know were available. She had discovered this by reading the library's welcome pamphlet, which she had read because she read everything placed in front of her, and which had mentioned the database in a single line in the 3rd paragraph that nobody had apparently read since the pamphlet was printed 4 years earlier. She had spent the following 4 years becoming expert in what that database contained and how to use it, not because she had a specific plan, because the information was there, and information that is there is information you should understand. The advanced academic program at Rensselaer Central had admitted Sophia at 11, based on standardized test scores that placed her in the 99th percentile in mathematics, the 99th percentile in reading comprehension, and the 98th percentile in logical reasoning. The 2 percentile gap in reasoning being the result, she had later determined by reviewing the test structure of a question whose framing contained an ambiguity that she had resolved differently than the test designers intended, which she had pointed out in a letter to the test publisher at age 12, and which the publisher had acknowledged in a form response that did not change the score, but that she had kept because it confirmed her interpretation. She had kept a lot of things. This was the other quality that the library had developed in her, alongside the information finding, the understanding that the record matters, that what gets documented gets preserved, and what gets preserved can be used, and what can be used gives you something that the people who never thought they would need it very badly wish they had thought to build. Her removal from the program had come as a surprise, but not a total surprise. She had noticed over the 3 years she had been in the program the pattern of who stayed and who didn't. Not who stayed because of grades. The grades were documented, the grades were clear. But who stayed when the grades were complicated by other factors. A disciplinary note, a teacher's comment about social adjustment, a parent's complaint. The students who stayed despite complications tended to come from families who could make phone calls to the right people. The students who did not stay tended not to. She had noted this without yet having the framework to document it formally. The framework came 6 weeks before the hearing, when she received the letter from the superintendent's office and read the phrase, academically and emotionally disadvantaged by the competitive environment created by Sophia's presence in the classroom, and recognized in it the specific language of someone who has been asked to justify a decision that was made for reasons the justification cannot name. She had opened the database. She had started pulling records. The donor disclosures were public filings. The superintendent's decision letters were public records available through FOIL. The program removal data for the past 3 years was available in the district's annual equity report, buried in a table on page 47 that nobody was supposed to look at carefully because the data in it told a story the district had not intended the report to tell. Sophia looked at it carefully. She built a spreadsheet. She ran the correlations. She found what she found. She had presented none of this to anyone before the hearing. Not to Daniel Park, who had not asked for it because he had not known it existed. Not to the legal aid organization that had agreed to support her case filing, because she had assessed that sharing it before the hearing would give the district time to construct responses to specific points rather than face the full weight of the documentation at once. Not to her mother, because her mother was working a shift the morning of the hearing, and Sophia had not wanted her to worry. She had carried it alone, in the brown accordion folder, on the city bus to the courthouse, through the security checkpoint where the officer had looked at the folder with mild professional curiosity, and she had said, "School documents," and he had nodded and waved her through. She had been carrying it alone for 6 weeks. She was very good at carrying things alone. It was one of the skills you developed when you grew up in the specific way she had grown up, with a mother who gave you everything she had, and for whom that everything, through no failure of its own, did not include an extra margin for the kind of worry that didn't have a solution attached to it. Sophia did not produce worry that didn't have a solution attached to it. She found the solution first, and then reported the situation. This was not something she had decided to do. It was something she had become, through the accumulated habits of a life in which producing worry without solution was a cost that landed on someone who could not afford it. She stood in the courtroom with the folder, and she waited for the moment when the solution could be applied. Judge Callis had given it to her by citing an overturned case. She had been ready for that moment or something like it since the afternoon she read the case file that Daniel Park had sent over and found 3 citations that she had then checked and found to be, in 2 out of 3 instances, applied in contexts the original rulings did not support. She had highlighted them. She had the correct readings in the folder. She had been prepared to address all 3 if the hearing required it. It had required only one. The one had been enough. Judge Callis had been speaking for 11 minutes. The subject of his speech, delivered in the elevated declarative register of someone accustomed to monologues that function as verdicts, was Sophia Reyes's removal from the Rensselaer Central School District's advanced academic program, a removal that had been ordered 6 weeks earlier by the district superintendent following a formal complaint filed by a parent whose son had, according to the superintendent's decision letter, been academically and emotionally disadvantaged by the competitive environment created by Sophia's presence in the classroom. The phrase was in the letter. Sophia had read it 4 times. She had memorized it, the way she memorized most things she needed to understand completely, which meant reading until the words became structural, until she could see not just what they said, but what they were designed to do. What they were designed to do was remove her from the program without saying that they were removing her because her performance made other students look bad, which was the truth. or because the parent who filed the complaint was the largest individual donor to the superintendent's most recent re-election campaign, which was also the truth, or because the school district had, over the preceding 3 years, developed a quiet but consistent pattern of managing its advanced program in ways that kept it comfortable for the students whose parents had the most institutional leverage, which was the largest truth of all. Sophia had found all of these truths. She had found them the way she found most things, by reading, by pulling public records through the state's Freedom of Information process, which she had taught herself at 13 because she had found a case in a civics textbook where a student had used it, and she had thought, that is useful. By cross-referencing donor disclosures with superintendent decision letters, by identifying the statistical pattern in advanced program removals over 3 years, which showed a correlation between family income and program retention that was not explained by any academic variable in the district's own records. She was 15 years old. She had done this in 6 weeks, in the evenings after school, on a laptop her mother had bought second-hand for $212. Judge Callis did not know this yet. He knew that she was a minor who had filed through a legal aid organization that had agreed to support the case, a formal challenge to her removal. He knew that her grades were exceptional. He had the transcripts, he had read them, he had noted them with the specific minimal acknowledgement of someone who finds exceptional grades in certain children unsurprising in the way they find other things unsurprising, which is to say, he had noted them without revising any of the assumptions the grades were supposed to revise. He knew that she had no parents present in the courtroom. Her mother worked a shift that could not be rescheduled, and her father was not in the picture, in the way that certain fathers are not in the picture, meaning completely and permanently. And he knew that her court-appointed guardian had been assigned 4 days ago and had the slightly unfocused quality of someone still learning the shape of the case they were carrying. What he did not know was what Sophia Reyes had spent 6 weeks building and what she had in the brown accordion folder on the table in front of her. He continued his monologue. He was addressing at the moment the question of whether the court had jurisdiction to overturn an educational administrative decision. A question he was answering in the negative, with the confident fluency of someone who has been answering questions in the negative for 23 years and has rarely been required to demonstrate that the answer was correct before moving on. He cited a case, not the full citation, just the name and a year, the way judges cite things when they are not expecting to be checked. Sophia Reyes uncrossed her arms. Judge Callis had been speaking for 11 of those minutes when Sophia identified the error. She had been listening to him with the particular quality of attention she brought to things that mattered. Not the surface-level attention of tracking the argument's progress, but the deeper attention of someone reading the argument's structure, its assumptions, the places where the logic relied on things that had not been established. She listened to his voice the way she read documents, looking for the gap between what was being claimed and what had been demonstrated. She was not impatient. She had never been especially impatient, even as a young child, in contexts where patience produced access to something she needed. She had sat through meetings and hearings and parent-teacher conferences that did not concern her and that moved at institutional speeds she could not control. And she had used that time productively, reading or thinking or making notes in the small notebook she kept in her blazer pocket since age 12. And she had come to understand that institutional processes are not slow because the people running them are stupid. They are slow because slowness is a feature of systems that have learned to protect themselves through inertia, and the patience required to work within them is not passive but active, a continuous, deliberate management of the awareness that the speed is wrong and the decision to work at that speed anyway because the alternative is to leave. She was not going to leave. She had 6 weeks of work in the accordion folder. She had gotten up at 5:30 that morning to review her notes. She had ridden the city bus to the courthouse in the January cold with the folder on her lap and the case law she had memorized running quietly in the back of her mind, available, waiting. When Callis cited the case, she felt something shift in her attention. The specific click of recognition that happened when a piece of information encountered a related piece already filed in the system she carried in her head. She had read that case name. She had encountered it in 3 separate searches during her preparation, always as a reference in other documents, never as the primary source. And she had pulled it up once specifically to check its current status, because the year of the citation had made her cautious, and what she had found had been the appellate division decision overturning it, dated 2017, which she had read in full, and whose reasoning she had understood and noted and filed. She reached into the folder, found the printout. She had printed 12 documents and organized them in a specific sequence based on the arguments she had anticipated, and this one was in position 4, which meant it was behind 3 others, and she moved through them with the practiced efficiency of someone who has organized a physical filing system with the same attention she brings to a digital one. She found it. She read the first paragraph to confirm her memory was accurate. It was. She looked at the judge, who was still speaking, building toward the conclusion he had already reached before he started. She said, "That case was overturned," and the room changed. What happened in Sophia Reyes's body in the seconds following that statement was something she would not have described to anyone who asked, because it was not the kind of thing she described, but it was real, and it was this, a specific physical awareness that she had crossed a threshold from which there was no return, which was different from the threshold she had crossed by filing the case in the first place, which was different again from the threshold she had crossed when she sent the letter to Dr. Whitfield. Each threshold had its own character. This one had the character of exposure, not the vulnerability kind of exposure, but the illumination kind. She had been carrying the folder for 6 weeks, and now the folder's contents were in the room, public, part of the record, available to the room and everything that happened in rooms. She was 15 years old, and she was not afraid. She was something more specific than afraid or not afraid. She was committed. She had made the only decision available to her when she identified what she had found in the data, which was to move toward it and not away from it, and she was still moving in that direction. And the direction was right, and the case was overturned, and the folder was in the room. She waited for the judge to respond. She reached into the brown accordion folder. She produced a printout. She looked at it for a moment, not studying it. She had already studied it. She was confirming her memory against the text, which was a different and faster operation. And then she said, in a voice that was clear and direct and not raised to any volume beyond what was necessary to cross the distance between her position and his bench, "That case was overturned." The room went quiet in the specific way that rooms go quiet when something has been said that reorganizes the space. Judge Callis stopped. He looked at her. She held up the printout. "Harrington vs. New York State Board of Education, 2014, she said. "You cited it as precedent for non-jurisdiction in educational program placement disputes. It was overturned by the Appellate Division 2nd Department in 2017. The controlling case since then is Morales versus Albany Unified, which establishes the opposite precedent, that state courts do have jurisdiction in cases where administrative educational decisions can be shown to have been influenced by non-academic factors." She said it the way she said most things in academic settings. Not aggressively, not with the performed triumph of someone waiting for a reaction, but with the flat, specific quality of someone providing accurate information and expecting that accurate information is the relevant variable in the current context. Judge Callas's expression did something complicated. It did not immediately settle into anger. It passed through several intermediate states: surprise, reassessment, the specific recalibration of a man trying to determine if he misheard, followed by the confirmation that he had not misheard, followed by the arrival at anger, which was where it landed. "Young lady," he said, and the temperature of the two words was not the temperature of a person correcting a misunderstanding. It was the temperature of a person who has been publicly corrected by a 15-year-old in his own courtroom and is responding to that specific violation. "I have been on this bench for 23 years. I think I am familiar with—" "You cited an overturned case," Sophia said, not loudly, with the precision of a statement that does not require volume to land. "I have the appellate division decision here. I also have Morales v. Albany Unified, the full text of New York Education Law Section 4410, and 3 additional state court rulings from the past 6 years that establish jurisdiction in cases with the characteristics of this one. I can submit all of them to the record if the court would like to review them." The prosecutor, who was 27 years old and had been hoping to get through this hearing without incident, looked at the table in front of him with the expression of someone who has just realized that the incident has already happened. Daniel Park, the court-appointed guardian who had read the file twice on the train, straightened in his chair. Judge Callas leaned forward over his bench. His face had settled into the expression that the building's unwritten orientation described, passed from clerk to clerk and attorney to attorney over 23 years. The expression that came before he said something that would end the possibility of the other person's position being taken seriously for the remainder of the proceeding. He had used this expression to shut down witnesses, redirect attorneys, and manage the 100 small moments in which someone had tried to slow the momentum of a proceeding whose direction he had already determined. He used it now. "I will not be lectured on case law by a 15-year-old girl who cannot even manage to behave appropriately in an advanced academic program," he said. "You are here because a school district made an administrative decision, and this court is here to confirm or deny its procedural validity, not to entertain the legal theories of a minor who has clearly been coached by someone who should know better than to—" What happened next was the thing that nobody in Courtroom 6 of the New York State Supreme Court, 3rd Judicial District, Albany County, had seen in 23 years of Judge Michael J. Callas's tenure. Sophia Reyes raised her voice. Not to a shout, not to the uncontrolled volume of emotion. She was not emotional in the sense of losing access to her reasoning. She was emotional in the sense that a person is emotional when they have held something back for a very long time and have identified the moment when holding it back is no longer serving the purpose that justified the holding back. She raised her voice to the volume of someone who has decided that the room needs to hear what she is saying, more than the room needs her to manage the comfort of the person she is saying it to. "You're the ignorant one," she said. The silence that took over the courtroom was total, not the silence of shock. Exactly, though shock was part of it, the deeper silence of a room in which a thing has been said that everybody present has, in some part of themselves, been thinking or feeling or carrying, and which nobody has said, and which the 15-year-old standing in the center of the room has now said clearly and without retraction. Judge Callas was frozen. His hands were still flat on the bench surface. His face was the face of a man who has heard something that his entire professional architecture was not built to process, because his entire professional architecture was built on the assumption that it would not be said, and the assumption had held for 23 years, and now a 15-year-old had said it, and the room had heard it, and the silence was the sound of everyone in the room calculating what happened next. Sophia did not fill the silence immediately. She let it exist for the 4 seconds it needed to exist. Then she said with the same directness, in a voice that had returned to its normal register, "You cited a case that was overturned 7 years ago. I found that in 40 minutes, with a legal database I accessed through my school library's academic license. I am 15. If I can find it in 40 minutes, you had 23 years to know it. You told me I can't manage to behave in an advanced program. I have a 4.0 grade average, a published research paper in a peer-reviewed undergraduate journal, and 6 weeks of public records documentation that shows the person who filed the complaint against me is the superintendent's largest campaign donor. I have not behaved badly in any academic setting in my life. I was removed because I was too good, and that embarrassed someone with more money than I have, and this court was supposed to be the place where that kind of thing gets corrected. That is what courts are for." She picked up the accordion folder. She placed it on the edge of the bench in front of her. "Everything I just described is in here," she said. "All of it is sourced, all of it is verifiable. I would like the record to reflect that I submitted it, and I would like the court to read it before making a determination." The room remained quiet. Judge Callis looked at the folder. He looked at it with the expression of a man who has never in 23 years had to look at something brought to him by a 15-year-old and assess it as evidence rather than as the production of a child. The assessment was visibly difficult, not because the folder was complex, though it was, but because performing the assessment at all required him to make a concession his posture had been designed for decades to prevent. He made it. He nodded to his clerk. The clerk collected the folder. The clock on the wall of Courtroom 6 showed 10:47 in the morning. The hearing had been scheduled for an hour. They were 37 minutes in. Nobody moved toward the exit. In the back row, Dr. Anne Whitfield had been writing continuously since the moment Sophia cited the overturned case. She was not writing notes. She was writing a letter. A formal letter on the State Education Department letterhead she carried in her bag, addressed to the Rensselaer Central School District Superintendent, informing him that the Office of Gifted and Special Programs had opened a formal review of the district's advanced academic program placement and removal processes, effective that date. She had been planning to write it after the hearing. She had started writing it during. What happened in the 6 weeks following the hearing in Courtroom 6 moved through the education system and the courts in the overlapping non-linear way that things move when multiple institutional processes engage simultaneously, and each one feeds information to the others. Judge Callis recessed the hearing for 2 weeks to review the submitted documentation. The 2-week recess was itself a kind of answer, a concession without language attached to it, the acknowledgement through process that the documentation required time that he had not initially allocated, which meant it had content he had not anticipated. When the hearing resumed, he had read the folder, all 41 pages of it. His clerk confirmed this to Daniel Park before the session started because the clerk had been in the building for 19 years and had developed over that time the capacity to read which documents the judge had genuinely engaged with and which he had performed engagement with, and this was the former. He did not apologize. Judges of his tenure and disposition do not produce apologies in courtrooms as a general matter. What he produced was more specific and in some ways more significant, a ruling that granted the court's jurisdiction under Morales versus Albany Unified and the additional precedents Sophia had submitted, ordered a formal review of the removal decision by an independent educational assessor appointed by the State Education Department and placed a stay on the removal's effect pending that review. It was the correct ruling under the law as it actually stood. Sophia had known it was the correct ruling for 6 weeks. She had known it since the afternoon. She found Morales versus Albany Unified in the school library's legal database and read it 3 times and understood what it meant for her case. She received the ruling on a Thursday afternoon. She was in the school library, Not the advanced program classroom, not yet. That waited for the review, working on the second section of a research paper on environmental policy that she had started during the 6 weeks she spent documenting the donor records. She read the ruling on her phone, put the phone face down on the table, and went back to the paper. Her mother called an hour later, having heard from Daniel Park. "Are you okay?" her mother asked. "I'm working on a paper," Sophia said. A pause on the line. The particular pause of a woman who has raised a child alone and has learned the specific vocabulary of that child's silences and non-silences and what they communicate. "Are you happy?" her mother asked. A different question. Sophia looked at the library window, at the January light over the Albany rooftops. "Ask me again in 6 weeks," she said, "when the review is done." Her mother made a sound that was not quite a laugh. "I'll mark my calendar," she said. The State Education Department's review took 8 weeks, conducted by an independent assessor named Dr. Patricia Kwan, who had been doing this work for 17 years and who read the materials Sophia submitted, including the statistical analysis of program removal patterns, which Dr. Kwan later described in her report as methodologically sound and reproducible, a conclusion not modified by the fact that it was produced by a 15-year-old student and who produced at the end of 8 weeks a 40-page report that found the removal to have been made without adequate academic justification and with procedural irregularities consistent with the influence of non-academic factors. The superintendent did not resign. He issued a statement accepting the findings and announcing revisions to the district's advanced program placement policies. The revisions to include an independent academic review component for any removal decision. The statement used the word regret once in a sentence whose construction distributed the regret across the situation rather than attaching it to any specific decision or person. Sophia read the statement. She identified the syntactic strategies in it with the same attention she brought to everything, and she set it aside. She was reinstated to the advanced program on the first Monday of March, walking into the classroom at 7:58 in the morning, with the same navy blazer and the same loose bun and the folder she used for that class under her arm. And she sat down in her usual seat, 3rd row, left side, next to the window, because the light in the morning came from the east, and she liked working in it. And she opened her notebook and looked at the board and wrote down the assignment. The student whose parent had filed the complaint was also in the room. He sat 4 rows back on the right side. He did not look at her. She did not look at him. There was nothing to perform between them. He had not filed the complaint. His parent had filed the complaint. He was 16 years old and was dealing with the specific and difficult condition of being the child of a person whose actions had consequences in the public record. And that was its own category of experience that did not require Sophia's attention. She attended to the assignment. Dr. Ann Whitfield published a summary of the department's review findings in the State Education Department's quarterly newsletter, without naming the district or the individuals involved, under the title Program Integrity and Academic Equity, a case study in administrative review. She also incorporated the statistical methodology Sophia had developed, the cross-referencing of removal patterns with socio-economic variables, into a new template for district equity audits that the department began piloting across 4 counties the following semester. Sophia did not know about the template until Dr. Whitfield sent her a letter explaining it, with a request for permission to cite the methodology's origin in the department's documentation of its development. Sophia was in the school library when she read the letter. She read it twice. Then she got out her notebook and wrote, at the top of a new page, a series of methodological refinements she had thought of since completing the original analysis, improvements to the statistical model, additional variables she had not included in the first version, a more rigorous approach to controlling for confounding factors. She wrote for 40 minutes. Then she put the notebook away and went back to the environmental policy paper, which was due in 10 days and which she had already decided would be the basis for an application to a summer research program at the State University of New York that she had found while researching the legal database for her case, and that accepted 1 student per year from the secondary school level. She submitted the paper. She submitted the application. She received the acceptance 8 weeks later. She did not tell anyone until her mother asked at dinner what the email notification she had seen on the counter was about. "A summer program," Sophia said. "What kind?" "Research," Sophia said. "Environmental policy." Her mother looked at her for a moment. "Is this because of the library?" she said, meaning the school library, where Sophia spent most of her non-classroom hours, where the legal database was, where the research that had started as self-defense and grown into something larger had been produced on a second-hand laptop between the end of school and the time the building closed. "Everything is because of the library," Sophia said. Her mother nodded. She understood this. She had grown up in a family where the public library was the largest room any of them had regular access to, and she had raised her daughter with the specific conviction that the distance between what you have and what you can do is, in many cases, exactly the length of the walk to the nearest place that lets you read for free. It was not a naive conviction. It had a condition. You had to be willing to do the reading. And you had to be willing when the reading showed you something that someone with more power did not want shown. To stand in the center of a room and say what you found, even when the person leaning over the bench toward you had 23 years and a silver nameplate and a building full of people who had been told that nobody yells at Judge Callis. The record now included the fact that someone had. The record also included the ruling he made afterward. The correct ruling, the ruling that followed from the law as it actually was, as opposed to the law as it had been cited from memory in a courtroom without anyone expecting to be checked. Sophia had checked. She went back to the paper. She kept reading. Daniel Park called her the evening after the first hearing. She was at the kitchen table with her research paper and a bowl of soup her mother had left before her evening shift started. And she answered the phone because Daniel Park's calls tended to contain actionable information rather than conversation for its own sake, which she appreciated. "I need to tell you something," he said. "Off the record, which means I'm telling you as a person, not as your attorney." "Okay," she said. "I've been practicing family and education law for 11 years, he said. "I've been assigned to this case for 8 days. I read the file twice on the train this morning." A pause. "You had better documentation than most adult clients I have worked with have in cases they have been preparing for months with full attorney support. You cited case law correctly in open court. You corrected a sitting judge's citation in front of 35 people and 2 reporters, and you were right." Sophia ate a spoonful of soup. "I know," she said. Another pause. "I'm not sure if you understand," he started. "I understand," she said. "I've been understanding it for 6 weeks. I needed someone else to be in the room when I showed what I had. That's why I filed through the legal aid organization instead of trying to handle the administrative appeal through the district, which would have kept it internal. I needed the courtroom because I needed the public record and I needed witnesses." She paused. "You were a good witness. So was the woman in the back row with the state education department." A long pause. "How did you know who she was?" he said. "I found her name in the department's organizational directory when I was researching the oversight processes. I sent her a letter 3 weeks ago describing the case and suggesting she attend." She finished the soup. "She came." Daniel Park was quiet for a moment in the way of someone revising a large assumption. "Sophia," he said. "Yes? Is there anything else in that folder that I should know about before the review hearing?" "I'll send you the index tonight," she said. "It's 11 sections." She sent him the index. "And He called the next morning and said he needed to read the full folder before they met again. She couriered it to his office by bicycle because she had a bicycle, and it was faster than the bus for that distance, and she had calculated the route the previous evening. He read it over the weekend. He called on Monday morning. "Section 7, he said. "The statistical analysis," she said. "The statistical analysis. You're 15. "The methodology is standard," she said. "I used a linear regression model with 2 control variables. I can show you the formula if that's helpful." "That's not. I know what a linear regression is." "Sophia." "I know. I was offering." He made a sound that was almost a laugh. "Are you always like this?" he said. "Like what?" "Like this." She considered the question. "I think so," she said. "Is it a problem?" "No," he said. "It's the opposite of a problem. I'm just recalibrating." She appreciated people who recalibrated. It was, in her experience, one of the more reliable indicators of a person worth working with. The willingness to update the operating framework when the evidence required it. Most people preferred to update the evidence. It was more comfortable. The evidence was the thing that had come in from outside. The variable. Your framework was the thing you had built over years. Revising the variable was easier than revising the structure. Sophia revised the structure when necessary. She had revised it several times in 15 years. Each revision had made the structure more accurate and therefore more useful. Which was the point of structures. She said, "I'll be at your office Thursday at 4 if that works." "That works," he said. She put the phone down and went back to the environmental policy paper. The paper was accepted to a regional undergraduate research competition 6 months after the Rensselaer case concluded. The competition was open to students in grades 9 through 12 across the northeastern United States. Sophia submitted under the category of public policy analysis. The paper received the highest score in its category from all 3 judges, 2 of whom wrote comments noting that the methodological rigor was unusual for a secondary school submission, and 1 of whom wrote, in a comment that Sophia read once and then set aside because comments from judges were not the measure she used. "This student writes and thinks like a graduate researcher, not a high schooler." She set it aside because she did not think of herself as a high schooler thinking like a graduate researcher. She thought of herself as a person with a question, finding the best available method to answer it. The label attached to the method was not the relevant variable. The accuracy of the answer was the relevant variable. She kept the paper. She put it in the same accordion folder that had held the Rensselaer documentation, which she had reorganized after the case concluded, into an archival system she maintained on the top shelf of her bedroom closet. Not as a trophy, as a record. The same way she kept everything, because what gets documented gets preserved, and what gets preserved can be used. And she had learned at 15 that you could not know in advance which of the things you preserved would turn out to be the thing someone needed. The month after her reinstatement, Sophia was asked to speak at a state education conference in Albany. Not by the district. The district was still processing its own institutional response to what had occurred, a process that moved slowly and involved several working groups and a consultant's report that Sophia had been told about secondhand. The invitation came from Dr. Whitfield's office, which was organizing a panel on equity in gifted education, and which had, in the 7 months since the hearing, become one of the institutional forces in New York State most invested in the methodology Sophia had developed. She accepted. She had conditions. She would speak for 15 minutes, not longer, because she had learned that the length of a presentation was not correlated with its usefulness, and she would address the methodology and its applications rather than the personal narrative of her own case. Because the personal narrative was not the point, and she did not want to be the point, she prepared for 3 weeks. She built slides, clean, minimal, with the statistical outputs displayed clearly against white backgrounds without decoration. because decoration was not what the data needed. She wrote her remarks in full and then reduced them to notes, because she found that writing the full version first produced better notes than writing the notes directly. She practiced in her bedroom with the door closed, speaking to the wall at the same volume she would use in the conference room, which was a room she had visited once specifically to calibrate the acoustics. She was 15 years old when she had filed the case. She was 16 when she stood at the front of the conference room and presented to 43 education professionals and policy researchers what a public school library database, a second-hand laptop, a linear regression model, and 6 weeks of systematic record pulling could show you about how a school district's advanced academic program actually operated versus how it claimed to operate. She was very clear. She was very specific. She did not editorialize. She presented the data and the methodology, and she let the room draw its own conclusions, because rooms that draw their own conclusions arrive at them with more conviction than rooms told what to conclude. At the end of the 15 minutes, she said, "The tools I used are available to any student with a school library card in New York State. The methodology is documented and replicable. I'll send it to anyone who asks." She gave her school email address. She sat down. She received 41 requests in the following 3 weeks. She responded to all of them. Dr. Whitfield, watching from the back of the room, wrote 3 things in her notebook. The first was a note to have the methodology formally adopted into the department's equity audit toolkit with attribution. The second was a note to reach out to the State Bar Association's Pro Bono Education Committee about developing a training module for education attorneys based on the documentation approach. The third was a note to herself, which said, "Remember this one." She underlined it once. Sophia did not see the notebook. She was already on her way to the bus because she had a paper due and a coaching session the following afternoon. For the 3 younger students she had started working with informally at the library's homework help program. Students who were doing what she had done at their age, finding the database, finding the tools, not yet knowing what to build with them. She was teaching them what to build, not as a lesson, as a practice, the way all useful things are transmitted, not through instruction alone, but through the experience of sitting next to someone who already knows and watching how they approach the work. She got on the bus. She opened her notebook. She kept going. Stories like this happen in school districts and courtrooms across this country every year. Young people with the intelligence and the courage to document what they find, sitting across from systems that have never expected to be read that carefully. If this moved you, share it, because the most important word in any proceeding is the one that says, "I checked." Subscribe for more stories the headlines miss.